I'm calling Claire Curran.
Mr. Chair. Well, Mr. Chair, this bill went through the Select Committee very fast over a year ago and came back to the House for its second reading, and it didn't have its second reading until a couple of months ago, and now we're into the committee stage. There's no doubt, as the previous speaker who chaired the Select Committee has noted, that cyberbullying is a significant issue, and this side of the House completely agrees with that and knows that there are serious real-life consequences for victims, and that the proliferance of communications, and particularly handheld devices that people have with them the whole time, has allowed for much more instant communication and for the consequences of that to be very real. And we also recognise that the current framework is inadequate, and so the need to have a new framework was important. The Law Commission went through a quite extensive piece of work around that. However, the bill that is before us and the bill that's gone through its various processes, Labor's had significant concerns about, and we have not resolved from setting those concerns out there. We continue to have grave concerns about the bill in its present form. We acknowledge, however, the work that the Minister's done to attempt to redress some of those issues in the bill, and we, despite that, we continue to have concerns, and we will be outlining those over the course of this evening. But on balance, the issues of cyberbullying we consider serious enough to warrant our support for the bill through the committee stage. We do, however, Mr. Chair, consider that the bill will have real problems in its execution and its application. It's going to result in cases being referred to the court that will waste the court's time. It will put pressure on an approved agency that is which is set out in the bill, and there are no guarantees that the approved agency will be properly resourced or properly skilled to deal with the mediation and legal work required, because this, Mr. Chair, is new territory, and one of Labor's considerable problems with this bill is that it's back to front, that it should have been the end of the process rather than the beginning. There should have been a comprehensive education program in place that enabled the community to become much better equipped, and agencies much better equipped to deal with cyberbullying before punitive new laws were introduced that were untested and created new offences that only apply in the cyber environment. Instead, this is where we've ended up pretty much first, and we've got no guarantees that there will be the resourcing and put in place to ensure that the new regimes will actually be able to actually be effective. The bill, as I said, was rushed through the Select Committee unnecessarily. There was a very, very important stakeholder group that never, ever got consulted, and that is the young people who are largely going to be affected, and the people that represent them, the people that's in schools and people who are parents. There should have been a much more extensive process throughout the community before this bill even came before a Select Committee, and unfortunately that didn't happen. So this is going to come when and if it is enacted, will come as quite a shock, I think, to large parts of the community in terms of the measures that are in place and the criminal offence that's in place and the penalties that are being imposed on that. Labor abstained from voting in the Select Committee on the bill, and we voted against it in the second reading, as I've said, and we did express a number of concerns, which I'm just going to quickly set out here tonight in my opening contribution. Mr. Chair.
Claire Curran.
Thank you. We believe that it has the potential to criminalise children, and it continues to have that potential to criminalise children for behaviour that's best dealt with through education and those interventions. Labor has an SOP in the House tonight to address that part of the bill, which provides that anyone under 17 cannot be convicted under Section 18 and Section 19 of the Act. And I urge speakers in the House tonight on this bill to read and consider that, and to think about the consequences of the impact on young people being put in a court situation and potentially convicted. We believe that the definition of harm is too broad, and we're certainly not alone in that. That's serious emotional distress, which is the definition, is that the inability to test that in any way until it goes before a court, and not just before a court but also before the approved agency, which will be dealing with the bulk of cases in the civil regime. They will have to initially decide what the legal definitions are and ensure that there is a balancing act in fact that takes into account free speech as well as emotional distress to the victim, and determine, and will they be equipped to do so? That is a really important question, Mr. Chair. Will they be equipped to do so? We are yet to know what and who the approved agency will be. As it stands, that there will need to be legal training involved in making those sorts of judgments. The proposed civil enforcement regime and the new criminal offences displace long-standing balance in New Zealand law, and they are being replaced with novel and untested standards. What this piece of legislation does is create a new criminal offence that only occurs in the cyber environment. It does not mirror an offence in the physical environment, and so therefore it's a completely new and untested means of addressing what is a significant problem, and we have concerns about that. We're not certainly the only group. The Labor Party is certainly not the only ones who are concerned about this. I know that many in the legal community also have concerns about this. We believe that it's also out of line with what is the trends that are happening overseas, which are more towards away from criminalisation and towards education and ways of dealing with things in the community that involve mediation and ensuring that the community is better informed and better equipped. We believe that it will be, that there are questions about whether it will be able to prevent harm, and that it will not provide a quick and efficient method of complaint and takedown. And I think addressing one of the major provisions in the Minister's SOP, which is around the safe harbour provision, which it allows for a 48-hour period in order to, if there is something harmful that's been posted, in order for the person that posted the harmful item can be contacted. That's a long time. That's an awful long time to have something very harmful up. So the Minister's SOP has enabled online content hosts, which, for example, an ISP such as Trade Me or whatever, to actually, if they have existing terms and conditions that they would rather use, such as taking the item down immediately, which I know organisations like Facebook and Google, YouTube often do, they are now allowed to use those provisions, their own provisions, which is a good thing, but they won't be covered under the safe harbour provision of the Act if they do so. So it's essentially it's a bit of a round the wrong way. So it means that there's harmful items are going to be out there in the public arena for quite a long period of time with no legal provision to take them down. and they will, and the effect of that is untested.
The Honourable Amy Adams.